Good afternoon, everyone.
Good afternoon.
We want to welcome you to the Tennessee Court of Appeals. The panel today consists of Judge Frison to my right, Judge Smith to my left, and myself, Judge McClarty. Mr. Clerk, are there any preliminary matters we need to consider before we start?
No, sir.
Then I'm going to ask that you call the first case on the docket, please.
Shaun Christopher Bruce et al. v. Tennessee American Water Company.
Thank you. Have you reserved your time?
I have 5 minutes, Your Honor.
Okay. In that case, you may proceed.
Thank you. Good afternoon. My name is Van Bunch. I'm from the Chattanooga area and represent the plaintiffs in this case. And may it please the court, here the trial court declined to certify a class of contractual water users in the city of Chattanooga and its environs after blowing up their water system during the course of a construction project, causing the community to be without water for at least 49 hours when they had to boil water, but people were in and out of water during that time, including businesses like the plaintiff in this case, Parkway Poorhouse, which goes by Trinity. And in those instances where there was no water or some water, people were suffering because this is a public water supply. Tennessee American Water Company is a for-profit natural monopoly. It's a wholly owned subsidiary of a publicly traded company, and it is duty-bound to engage in reasonable best efforts according to standard engineering practice to ensure the water supply is safe. And on top of that, to protect the water company from being sued in a class action every time some intersection main breaks, the only time that the company is answerable in damages for its conduct is when it engages in willful default or neglect in causing the damage. That issue, whether the company engaged in willful default or neglect that led to this water outage, is the common issue in this case that binds everyone together. The judge here declined to follow both many cases penned by yourself and Judge Frierson, Judge Sweeney, in a long line of Tennessee class action cases to look at what commonality means in a class action. As you know, class actions are favored, where the individuals in the class are subjected to a common event, or because they have a contract, the contract is breached as to all of them, as a way of resolving the claims. Because if the jury decides in this case that Tennessee American Water Company, in conducting this operation at its plant, willfully defaulted or neglected in its duties to engage in reasonable engineering practices and do this service in such a way that it would not cause this outing, everybody who was damaged by it would have a judgment in hand, and they could then go and pursue their own claim. So this is not a case where we're saying, here's an event, here's an expert, the expert has decided that there's been damages of X amount and we're just going to allocate them according to share value or something like that. Admittedly, this case will require at least two phases. One, the conduct of the water company, and then two, people coming in, judgment in hand, saying, here's my damages. For example, in General Sessions Court with the $25,000 limit, you can go in with, like the plaintiff in this case, Parkway Poorhouse, and say, we had to buy bottled water, we had to buy ice, we had to buy other water-related goods to serve to our customers. And we lost $9,000 is the testimony in this case on one single day of income because we had to shut down. The Hamilton County Health Department told restaurants shut down. And for all he would have to do under Tennessee law is come in with his receipts, and up to $10,000, those receipts are presumed valid. So you file the case in General Sessions Court, you get your recovery, you recover your cost of suit, and the company doesn't walk away scot-free for blowing up the water system. What happened here, though, is that the judge decided that because the tariffs and regulations talk about reasonable level of service, that each individual has to come in and say the level of service was deficient in order to make a claim. But that's putting the cart before the horse. And if that was a rule, there would be no such thing as class actions, because everybody, certainly in a negligence-related class action, the measure of damages fluctuates wildly person to person, and they have to come in and prove it up. But that's not a hindrance, and it's not an impediment to holding a company responsible for causing the damage in the first place. We provided the court with 37 years of class action cases that were certified in the single event man-made disaster cases. You know, some of them would come to mind, like BP Horizon, Velsicol, Sterling versus Velsicol, which is a case often cited by this court, was just such a case where there was a poisoning of an area around a factory, and they said deciding where that poison came from was of sufficient import to bind the class together. Here we submit that deciding if the company abided by its contractual obligations binds the class together, and then we can let the chips fall where they may. We have, as a group of lawyers, this is our fourth case against this company, not the Tennessee American Water Company, but American Water and its subsidiaries. And in West Virginia, the West Virginia Supreme Court of Appeals, having looked at the case twice on writ, followed exactly the blueprint that we urge your honors to follow in this case, which is they had the same regulation. Effectively, the defendants have admitted basically they had the same obligation to provide reasonable water service there as they do here, and then they separately had the obligation to design, build, and operate and maintain their water system so that it would provide water. And what we're saying is that design, build, and operation side of the equation is where it binds the class together, because if you prove that, everybody has to prove that. Even if you have a $9,000 claim, you still have to prove that fact. And in keeping with what class actions are supposed to do, because nobody has a claim big enough to sue them, nobody, they will walk away without being adjudicated for their conduct of blowing up the water system in Chattanooga. That's the line of cases that the judge didn't follow. You know, he's duty bound to, as a judge, follow similar cases, reasonable lines of inquiry. What he also didn't do in this instance is follow the teachings of our own Court of Appeals. He didn't follow Megan, where he said, you know, it's important to give people access to justice. That was a case where there was a railroad line across hundreds of properties. Every single person had to come in and prove the loss of value of their property, but the common issue that bound them was, did they have the easement in the first place? If they didn't have the easement, then they were trespassing, and everybody could sue for trespass damages. We got the Megan case. You've got what this court penned in prior work was, it's called Rogers versus Adventure House. And it's a case where this court, this judge in this case, understandably relied on the Court of Appeals upholding his denial of class certification in that case, and it could not be more different than the case that we're deciding here today. In that case, over a period of time, there were one or more contaminations of the water in a restaurant coming from either a well or the tables. Everybody from the COVID era knows what fomite means. Now it's just like touching something and getting sick from it. Or contact with employees, and whether the employees were in contact with the water or the tables before they were contacted the customers, and it was a multi-source issue. You could not tell in a common issue class where the source of the damage came from. Here, we know it's the water company.
Thank you, sir. You have your response. Yes, sir.
May it please the court. My name is Kent Mayo, and I'm here on behalf of Appellee Tennessee American Water Company. There are certain anchoring principles that are critical to this court's review of the trial court's decision denying class certification. First, there is no right to class certification in Tennessee. As the Tennessee Supreme Court recently recognized in its April 2025 ruling in emergency medical care facilities at page 19, a ruling granting class certification leads almost always to settlement. This is because of the enormous risk that certification places on a defendant, regardless of actual liability. Consistent with the significance of the class decision, the Supreme Court emphasized at page 10, note 6, that courts should not disregard the requirements for certification despite the perceived benefits of allowing a case to proceed as a class action. These requirements for certification are set forth in Tennessee Rule 23, and there is no dispute that it's plaintiff's burden to meet all of the requirements that must be met. Ultimately, the trial court here exercised its discretion in reviewing the evidence presented and ruling that the plaintiffs did not meet their burden under Rule 2301 for either their original class or their amended business class, and those rulings are entitled to deference by this court. The trial court also made critical factual findings that support its rulings. The trial court's obligation in evaluating certification under Rule 23 is to conduct a rigorous analysis. Here, as part of that rigorous analysis, the trial court reviewed the available evidence and made specific factual findings that there were significant differences in the nature, type, and duration of impacts on the named plaintiffs and their individual water service. Some had reduced pressure, some lost water, some had just the boil water advisory, and all were impacted in different ways over different time periods. The trial court also noted critical admissions by plaintiff's expert Wayne Lorenz. Lorenz admitted he could not say that all customers lost water service. He testified that the only way to determine whether and how long a customer experienced the loss of water or reduced pressure would be to conduct an individual interview with that plaintiff. Ultimately, as summarized by the trial court, not all of Tennessee American's customers had the same experience. Some customers had no disruption, while others had disruptions to varying degrees. These factual findings are entitled to a presumption of correctness by this court and support affirming the trial court's determination under Rule 23. Turning to the specific issues on appeal. First, contrary to plaintiff's assertions, the trial court appropriately defined and interpreted Tennessee American's contract obligations under its tariff for purposes of the class certification analysis. An important threshold task for conducting a rigorous analysis under Rule 23 is to define the elements of plaintiff's claims. Here, the trial court correctly found that Tennessee American's baseline contractual duty is to provide reasonably adequate water service, not perfect or continuous service that is at all times free from interruption. This determination drives the class certification analysis because whether this contractual duty has been breached is dependent upon whether an individual customer's water service was impacted by an unreasonable interruption or a failure to provide adequate water service. And the trial court was right in identifying Tennessee American's duty under the contract as providing reasonable water service to its customers. That's what a water company does. The controlling principle in contract interpretation is to give effect to the intention of the parties. First, Tennessee American's status as a public utility regulated by the Tennessee Public Utilities Commission is important to assessing intent. The company's tariff is approved by the Commission with the intent to provide reasonable limitations on liability risks that could otherwise impact the utility's ability to satisfy its obligations. And any interpretation of these tariff provisions has to give effect to these liability limiting principles. Second, the intent is also clear, considering the whole of the tariff and the applicable regulations, that Tennessee American's obligation under the contract is to provide reasonable water service. The tariff contains multiple provisions that confirm this standard of reasonable service. Section 26(1) of the tariff highlights the contrast between reasonable and uninterrupted service, stating specifically, the company will undertake to use reasonable care and diligence to prevent and avoid interruptions and fluctuations in water service, and to maintain reasonable pressure on the distribution system. But it cannot and does not guarantee to furnish at all times any given quantity for fire or general purposes where the interruptions or fluctuations in service won't occur. Sections 18(1) and 25(1) of the tariff say similar things, as do the TPUC regulations that are part of these, part of the contract and part of the complaint that plaintiffs filed. The two key takeaways from reading these contractual and regulatory provisions together as a whole and consistent with their intent, as is required, is that one, the requirements for demonstrating a breach of contract and a breach of duty focus on the provision by Tennessee American of reasonably adequate service to its customers. And second, unless Tennessee American fails to provide that reasonably adequate level of service, it cannot be found to have breached the contract with that customer under any circumstances. It's important to realize that doesn't create absolute immunity for Tennessee American, as counsel suggests. Under the tariff, if Tennessee American does act with willful default and neglect, it can be held responsible for deficiencies in water service, but those deficiencies must be outside the scope of the company's obligation to provide reasonable water service. Plaintiffs' alternative read of the contract is improperly narrow and unsupported. Essentially, they argue that a single word in a single sentence of a single paragraph of the tariff nullifies all of the remaining tariff and regulatory provisions. Plaintiffs go to great lengths to construct a reading of the contract that would avoid the need to make an individual inquiry into reasonable service for individual customers. Initially, plaintiffs ignore the first sentence of Section 26(1), which, as we just talked about, expressly disclaims any guarantee of uninterrupted service. And they cite only the second section, or the second sentence, of that section, which says, in the event there occurs any excess or deficiency in the pressure, volume, or supply of water for any cause whatsoever, other than willful default or neglect on the part of the company shall not in any way or under any circumstances be held liable or responsible to any person, firm, corporation, or governmental unit for any resulting loss or damage. Plaintiffs then focus even more narrowly on the words any or deficiency to say that these words create strict liability for failure to provide perfect service. This reading simply cannot be squared with the language, structure, or protective intent of the contract or with plain common sense. A couple of things about that. First, this interpretation makes no practical sense because a utility cannot design to or operate to achieve perfect service even under normal operations. Those fluctuations in pressure and in service will happen in day-to-day operations. Second, plaintiffs have to rewrite the language that I just read to you of Section 26(1) to extract their preferred meaning. Plaintiffs have twisted that language from an exception to liability, as it clearly reads on its face, to a direct statement of strict liability by turning the words around. There's no indication in the contract that the use of the term any was intended to transform that obligation of reasonable service into one of uninterrupted service. Third, plaintiffs' reading violates common sense because it turns the intent of the tariff provisions upside down, flipping a structure intended to limit public utility liability into one that creates substantial additional risks. For example, under plaintiffs' reading, all they have to do is certify a class is allege willful default or neglect, and then show that some group of customers had a change in pressure of 1%. That would be any deficiency in pressure under their reading. That type of pressure change event literally happens every morning in the system when people get up and turn on their showers. That type of unlimited liability is completely inconsistent with the intent of the tariff to protect public utilities from uncontrolled risks. This court should affirm the trial court's reading of the contract and reject plaintiffs' unsupported interpretation. I want to briefly discuss the boil water advisory. Plaintiffs argue that the mere issuance of the precautionary boil water advisory, should provide a shortcut for their obligation under the contract to provide evidence that can demonstrate a lack of adequate water service on a class-wide basis. But the trial court appropriately rejected plaintiffs' argument after reviewing the contract provisions and looking at the facts in the record regarding the BWA. The court made several relevant findings, including that Ms. Schaefer, the sole residential class representative, did not follow the BWA and thus was not affected by it, and plaintiff's expert Mr. Lorenz acknowledged that people react differently to receiving a precautionary BWA. Based on its record review, the trial court found not every impact that did occur, whether associated with loss of water, loss of pressure, or implementing the precautionary BWA, would establish a breach of contract. Contrary to plaintiff's contentions, this is an appropriate and defensible finding based on the evidence assessed by the trial court under a rigorous analysis and not a premature ruling as a matter of law. I want to move to the Rule 23 issues, Your Honors. The trial court's determinations that plaintiff failed to satisfy Rule 2301 factors for both classes are entitled to deference. Plaintiffs bear the burden of proving each required element under Rule 2301 for each proposed class. And as this court explained in Rogers v. Adventure House, the grant or denial of class certification is discretionary, and the court's decision will stand absent abuse of that discretion. Here, the trial court conducted a rigorous analysis and held that plaintiffs failed to satisfy multiple elements of Rule 2301 for each class. Tennessee American believes the trial court's ruling can be upheld with respect to each of those requirements, but the court need only find that plaintiffs failed to meet their burden on any one of the requirements to affirm denial. I'm going to focus solely on commonality given our limited time here. Plaintiff's argument is tied substantially to its position that commonality presents only a very low bar under Rule 2301. But this court and the U.S. Supreme Court have recognized that a plaintiff cannot meet its burden simply by identifying any random common issue. As stated in the Rogers decision, where common questions will not elicit common answers leading to class-wide relief, the trial court does not abuse its discretion by determining that the commonality prerequisite is not satisfied. That is exactly the situation we have here. The trial court applied the standard for breach under the contract and correctly found that commonality is not met because plaintiffs cannot show breach or liability using common proof. This holding was based on a review of the record evidence, including specific factual findings regarding differences in the impacts of water service, concessions from plaintiff's expert Mr. Lorenz that he can't say whether specific businesses or residences were actually impacted or not, and findings for plaintiff's amended business class, which though narrow, suffers from the same flaws because there are also significant differences among the business impacts, and the terms for identifying potentially impacted class members are very individualized in nature. Plaintiffs raised multiple complaints regarding the trial court's order, but none of them abate their failure to meet their burden to meet Rule 23. First, and counsel said this earlier, plaintiffs continue to misstate the nature of the issues the court was evaluating for class certification purposes. Under the contract, the individual inquiry as far as reasonable service goes to breach. That means part of the liability finding in this case. It does not just go to damages. So this is not so simple as to split the case up between liability and damages. You actually need to look at those issues of individual inquiry for liability, a critical distinguishing factor. Second, the trial court rejected plaintiff's position that any claim of a common course of conduct by Tennessee American automatically satisfies commonality and supports certification of a class. The trial court specifically found here the conduct of Tennessee American is not independently sufficient to establish a breach of contract under the applicable tariff and regulatory language. That finding honors the important threshold commonality requirement that this court found in Rogers, that there must be common questions that are capable of generating common answers apt to drive the resolution of the litigation. The trial court appropriately distinguished the course of conduct cases like Wofford, Freeman, Highland Physicians, and Bowles because the alleged breaching conduct by the defendant actually was enough by itself to satisfy the breach of duty. Again, that's not what we have here. Here we need to have those individual inquiries to find liability. That's not the case in those other cases cited by plaintiffs. And the trial court found that specifically. For those reasons, the court should defer to and affirm the trial court's reasoned and rigorous analysis regarding commonality. I want to close by just speaking briefly about plaintiffs' seeming references perhaps to a potential issues class or a potential focus just on the question of willful default or neglect. The trial court here specifically considered and determined that plaintiffs did not meet the requirements for establishing an issues class under Rule 23034. The trial court specifically found in each order that an issues class or bifurcation seeking to focus on willful default or neglect cannot avoid the issues with commonality, typicality, or adequacy, and the court denies plaintiffs' request for a narrower certification. In each of those orders and each of those findings, the court cited this court's decision in Rogers, where a similar request from plaintiff was rejected as not curing the failure to meet Rule 2301. I want to just mention, with a little bit of time left, there was a question raised or a point raised by counsel saying that there are a number of these what he called single event cases that have been decided over the years on class action. But I think that's very misleading, because what you need to do when you're looking at class action is you need to apply the standards under Rule 23. And putting aside any policy about whether or not it's a good idea to help people with smaller claims get into class, you also have comparable and competing obligations to look at whether defendants are adequately protected, and that is what Rule 23 does. It actually has a compromise of those different public policies around class. And so the way that you solve this is you need to look at each case on each individual fact pattern, and you need to look at that under Rule 23. The single event cases cannot skip over that and just say, Rule 23 doesn't apply, you can just skip to certification because it's a single event case. And many of the cases that are identified in plaintiff's briefing are wholly distinguishable from this case. So I think it's important. Rule 23 is the guiding principle here. The trial court, viewed through the applicable lens, interpreted the contract correctly, evaluated class certification with a rigorous analysis, and appropriately enforced the requirements of Rule 23, and their orders denying certification should be given deference by this court and affirmed. Thank you, Your Honors.
Any questions? Thank you very much, sir. Your rebuttal.
Thank you, Your Honor. It is true that the tariff language says, under no circumstances will this company be liable without a showing of willful default or neglect. That's what our focus on any means. There are other duties and obligations set forth in the regulations in the tariff about what the company shall do in accord with its obligations to provide water to the community. In the briefing, the defendants use the word should, which is definitely in the law, not shall, because the law is they shall design and construct a water plant to conform to good standard engineering practice, design and operate it so that it will provide reasonably safe and adequate water. It's the focus there is on the conduct of the company, not the impacts on the community. As I mentioned before, there would be no class actions if everybody had to be impacted the same way, other than maybe a misapplied tax or something of that nature. This issue of the duty, including impact, was handled by the West Virginia Supreme Court of Appeals in a very similar case against a sister corporation of Tennessee American Water, West Virginia American Water. And they said, while it's true that in order to determine the breach, you have to look at the impact at some time, the duty is the duty to construct and maintain it in a suitable condition to prevent service interruptions, and the company breached or did not breach that duty based on the condition that the system was in at the time of the main break, and whether that condition was up to the standard required under the contract judged before the break occurred. The state of the facilities and equipment and the alleged absence of feasible improvement and or mitigation measures was the same, this is the West Virginia Supreme Court of Appeals talking, as would be applied in a negligence or a statutory breach case. So you have to look at, in this instance, not just what the duty is, but what do you have to do to prove a breach of that duty? You have to show, if you're an individual plaintiff, that this company was operating the system in a negligent manner so that it created this debacle. That's true of every single person. And once you have that judgment in your hand, you have to go in and prove that you were impacted by it. Now, how hard is that? I lost water for 18 hours. The jury awards me whatever. The General Sessions judge awards me whatever. That is a low end of the scale, all the way up to people who lost profit. But all they have to do is testify that they lost water. And this is not an invitation for filing false claims or anything. These people actually suffered. If you have to close your business, I don't know if y'all are very familiar with operating, let's say, a restaurant or a bar, but it's a narrow margin, and you can't afford to lose a day of, or two, or here, 3 of income. So the first issue that I'd like to dispel there was that the contract itself does require 2 showings, one of which is a common class-wide issue, as recognized, like in the Wofford case. You can have issues within elements of claims. This does not, in 2303-4, it talks about whether there's a sufficient issue to bind the whole class together. It's called an issues class. It's recognized by the Sixth Circuit, Judge Stranch writing in Martin versus Baer case, which was a pollution case. And they said the scope, there were 7 issues certified, but the scope and extent of the pollution, and including whether it came from this defendant or that defendant, are all common issues sufficient to satisfy and warrant certifying a class. Judge Posner, in a case called Medrick, which is in our briefing, went so far as to say that to deny certification in a case where the common conduct of a defendant has such a wide impact on people based on the impact just speaks of disfavoring the case, the class action device, and not providing justice.
Thank you, sir. No questions. Thank you very much. We want to thank both the attorneys for your presentation. Your case has now been submitted to this court for resolution. You should receive our opinion and judgment within a reasonable